session, welcome back. And those of you who are new, welcome to the conference. Thanks for braving the weather to come out. And hopefully you're finding it very educational and informative and enjoying it. This afternoon's session, we're going to be talking about Arizona's military facilities. And specifically, we're going to talk about changes to state laws with respect to protecting military facilities. Now, when I say changes, that kind of implies, well, something new has happened. Well, as a matter of fact, the changes are actually 15 years old. But they affect a lot of different properties here in Maricopa County. And since it's a statewide law, it affects properties throughout the state, as a matter of fact. And there's a lot of people that still don't know anything about this. And these are people that are directly affected. Property owners, developers, etc. I kind of am the point person for the Luke Air Force Base program, and I get calls every day from people saying, what is this new law? And when I say it's 15 years old, they're like, why wasn't I told about it? But at any rate, so what we're going to do is talk about these changes and how they affect Maricopa County. They also affect numerous cities and towns here in the county as well. So if you do any work in those particular communities, you might be affected as well. These changes affect land around Luke Air Force Base and also around the two ancillary military facilities here in Maricopa County, and I'll explain what those two are and where they're at. This is, to me, a very interesting topic. There's a lot of history behind this. So we're going to talk about the history of the legislation. There was an important court case regarding this. We'll talk about the outcome of that, what it means to everybody affected. So I'm going to be throwing a lot of dates at you because I'm going through 15 years of history in about 20 minutes. So feel free to raise your hand and say, whoa, slow down, or hey, I got a question. Very informal, so feel free to just chime in at any point. So let's get started. So it all starts back in 2004. Then Governor Janet Napolitano signed a couple bills, House Bill 2140, 2141. The numbers don't mean much, but basically what those bills did is they strengthened existing protections around Luke Air Force Base and also extended those to the ancillary military facilities. Up until that point, there were some protections for the military facilities, but this certainly strengthened them and extended it to all the military facilities. So it's a statewide bill or law. It affects Luke Air Force Base, the two ancillary military facilities, and I'll talk about those. Davis-Monthan down in Tucson, and the Marine Corps Air Station Yuma. I always get those words wrong. But anyway, so those are the ones that it's affecting. What these laws do is they require affected jurisdictions to adopt land use plans and zoning ordinances to assure development is compatible and consistent with high noise or accident potential generated by military airports or ancillary military facilities. That's a mouthful, but that's exactly what it is out of state law. Okay. The high noise or accident potential zone, that's what it's applicable to. And I'll show you a map of what that means, but it effectively means these accident potential zones off the ends of the runways. Those are the areas where the highest potential is for accidents on either landing or taking off of military aircraft, as well as these irregularly shaped circles around the military facilities called noise contours. And those noise contours vary in decibel level from 65, 70, 75, 80, and up to 85. Basically what it is it's an average noise level averaged over a period of a year. And it was an extensive study to identify where these are actually located. If you are affected by this, it's a good thing to understand and learn this law. It's codified in Title 28, 8461 and 8481. So I would definitely recommend familiarizing yourself with that. And here in Maricopa County, here's the jurisdictions that it affects. So it's not just unincorporated area, but if you do any type of work in any of these cities, it may impact you as well. So here's what the high noise or accident potential zone looks like around Luke Air Force Base. Just for reference, if you're not familiar with the West Valley that much, Luke Air Force Base is out here. Here's the 101, I-10, and the 303. This is what I was talking about. These are the accident potential zones off the ends of the runways, and these are where the planes take off and land. and then the various noise contours that surround the base. So outside is 65, 70, 75, 80, etc. Okay? Now, as I mentioned, it's not just unincorporated Maricopa County, but it affects a lot of the jurisdictions out there. So the areas in white are still unincorporated, but you can see it also affects Glendale, Surprise, El Mirage, down here is Goodyear, Buckeyes down here as well. So these jurisdictions are affected as well. This is the auxiliary airfield number 1, it's called. This one's up near Surprise. It's actually in Surprise itself. This is Grand Avenue, US 60, heading up towards Wickenburg. Whitman is over here. What happens is, this is actually controlled by Luke Air Force Base, the Department of the Air Force. And what happens is, the planes take off from Luke Air Force Base, which is down in the southeast. They fly out over the White Tank Mountains, and what they'll do is they'll come around, and they'll use this as training for instrument approaches. This auxiliary airfield doesn't actually exist anymore. It was at one point an active airfield back in World War II and the years following, when they were training pilots back then. But since then, they decommissioned it. If you look on an aerial, you can still see remnants of a runway, but they don't actually use it. So what they do is the planes will come in, do low instrument check approaches, fly over it, and then gun the engines and bank out to the north like that. It's extremely loud if you've ever been out here, but it's kind of cool actually. So that's why you see this irregular shaped banking off to the north with the noise contours. So they don't actually land, but they do use it for training purposes. And this just shows City of Surprise is in the yellow with the base and then up to here. So this one primarily affects the unincorporated county, but also the City of Surprise is affected as well. The Gila Bend auxiliary field. For reference, this is Interstate 8 here. Town of Gila Bend is right here. This is State Route 85. This is the road that goes down to Rocky Point, if you're familiar with that. This particular facility, while it's in the middle of nowhere, is extremely important to the military, the Department of Defense. The facility itself is actually on the Barium Goldwater Gunnery Range, which is the largest training facility of any kind in the United States for the military. It's approximately 2 million acres, and it extends from Pinal County all the way over to Yuma. All branches of the military use this facility. It's not just Luke Air Force Base. So they use this for Luke Air Force Base with the F-16s and now the F-35s, use the gunnery range for live fire exercises. The A-10s down in Davis-Monthan and Tucson fly up and use this as well. Marine Corps Air Station Yuma uses it both for aerial training as well as troops on the ground through helicopters. And actually the Navy uses this as well. They'll fly jets off of carriers in the Pacific and come in, do live fire exercises in return. This is a very valuable piece of real estate for the Department of Defense. It is literally the perfect conditions for what they need to do, not only from the weather standpoint, but the terrain mimics a lot of the hot spots in the world. You've got very rugged mountains, there's valleys in there, and there's also very flat terrain in the lower levels as well. So it's a very valuable piece. The Gila Bend Airfield itself is used as an emergency facility. If a jet develops problems and they can't make it back to wherever they came from, they will land them here for safety, do the repairs, and then send them off. So this one is extremely valuable, even though it's actually on the gunnery range itself. This kind of shows where it's at. This is the range here. Some of this is BLM land, Bureau of Land Management. So that's what they use that one for. So continuing on with some of the history on this. So as I mentioned, the law was passed in May of 2004. The problem that we had, sort of down here, is that you have this new state law that says there are land use restrictions in these areas now. Okay, that's one part of the statute. But on the other hand, you have parts of the statute that say you have your zoning, and that's your entitled right to do. So we have this conflict in statutes, okay? So what the county did was it sent a letter in September of '04 to the Attorney General saying, we don't know how to interpret this. What law takes precedence? Is it the new one? Is it the existing entitlement for the zoning? This says you can't do residential, this one says you can. How do we interpret this? Well, the Attorney General didn't respond right away. We sent a second letter, but then in December, they said we take no position on issuing building permits. Up until that time, for several months, we had a temporary suspension on the issuance of building permits until this thing could be resolved, okay? So when the Attorney General says we don't take a position on it, we lifted the suspension and started issuing permits again in compliance with the existing entitled land, which again is mostly rural 43. And basically what that means is effectively one house per acre of land you can do. It's a rural zoning district, but that's effectively what most people use it for, is one house per acre.
Matt, can I?
Sure, absolutely.
Is this law and regulation based on the civilian airports to start with, and then they extrapolated it out to go to the military ones, or how do they? I know they've got restrictions along, for Sky Harbor and some of these other airports. Is that based on the same? No,
it's something different. The FAA governs a lot of the restrictions around commercial and civilian airports.
This is something part of it.
Well, not necessarily, except for the individual zoning regulations in the cities themselves. So, for example, the city of Phoenix has zoning restrictions with
based
respect
on
to
FAA requirements,
and there's FAA requirements as well. But this is something separate and distinct that the state took on.
I would just wonder if you copied each other a little bit.
Because the federal government did not, they're not the ones that initiated this process. This was purely at the state level. And the reason being is that from an economic standpoint, the military facilities generate a lot of income for the state. Luke Air Force Base is over $1 billion itself. So they wanted to make sure that those things were protected. Exactly. And at the time this was passed, the military was going through the Base Realignment Committee, the BRAC, where certain facilities were being decommissioned. And they had a list of criteria of what they were looking at in order to decide which bases were going to be closed. Top of that list was, can this facility, going forward, meet its stated purpose? Well, Luke Air Force Base is to train pilots. And if you have a bunch of incompatible land uses where the planes can't fly, that's a serious problem with the federal government. And so they were seriously concerned about the base being closed down and having the training sent to somewhere else. So December of 2004, permits start again. So things were going along fine for the next 4 years. And then in March of 2008, the Attorney General at that time issued an opinion that said, well, no, pre-existing zoning doesn't exempt the county from restricting development. So now we have this conflict that we tried to resolve in 2004, but okay, we're in 2008. So there was a dispute over which statute took precedent, the zoning or this new statute. And there was a lawsuit filed by the Attorney General's office against the county, and then there was also a countersuit by the county to effectively establish once and for all, what does the law mean, how do the zoning rights play into that, and how do we deal with all of this? Well, in January of 2009, there was a court hearing with the Arizona Superior Court, and they issued, the judge issued his decision in February of 2009. This is actually the decision here in CV 2008-019301. It's very interesting reading. So if you're into that type of thing, go ahead and check it out. It's got some interesting decisions on it. But basically what the court said is they upheld the state law and said this is valid law, and county, you need to comply. So with that, the county began discussions with the Attorney General's office about what the final court order would look like, because the court said, AG, you draft it up and bring it to us. And so they started doing that, and we actually reached an impasse over where the single-family residential can actually occur. Under state statute, and I'll show you this chart here in a second here, certain areas of that high noise or accident potential zone say you can do residential provided you noise attenuate to keep the sound down. That would be within the 65, 70, and even the 75 LDN noise contour. So what we did is, our draft ordinance, we literally cut and paste that chart out of Title 28, put it in our ordinance, sent it to the Attorney General's office for certification, because the court said the AG's office has to certify it. They sent it back saying, no, we're not going to certify it because this would allow residential. Even though the chair says you can do residential, they said, no, you can't do that. So it went back to the court after the county filed an objection to the form of judgment. The court basically kind of dismissed it and signed a 180-day compliance mandate. So we had 6 months from that point to get a comprehensive plan and a zoning ordinance that would meet the statutory requirements and have the Attorney General certify that it was in compliance. Well, in February of 2010, after some discussion and negotiation, the county and the state reached a settlement agreement concerning residential development in these areas. And this is basically what it says here in this settlement agreement. It says, Maricopa County agrees to prohibit residential development in these areas except under certain conditions, and I'll talk about those. In return, the state will indemnify and hold the county harmless for its compliance on a case-by-case basis. The county at the time was very concerned about, if we go above and beyond what the state law says, does that open us up to potential takings claims and liability for a state law that the county taxpayers would have to foot the bill for? The state disagreed. They said, we think this is a sound law, and so what we will do is we will agree to indemnify the county if there are any claims, takings claims, tender it over to us within 10 days, and then we will defend and hold the county harmless. Okay? So we said, okay, that works for us. So then in March 2010, we adopted our comprehensive plan and our zoning ordinance. We got it certified by the Attorney General, and we set up these two new processes called a use compatibility and consistency determination and a military compatibility permit. Now these are totally new processes. There is no zoning changes, there's no rezonings, there's nothing else like it within these affected areas. Effectively what this means is, the first step in the process is, someone comes to us and says, I would like to do this on my property, on this particular parcel. What we then do is we take that, we process a letter, and we send it to Luke Air Force Base and say, do you consider this particular use on this particular parcel compatible and consistent with your operations? They will either send us a letter back saying, yes, it's fine, it's good, which in that case would allow the county to make a similar determination, because under state law, both parties have to mutually agree. Or if they said, no, it's not compatible, then that would preclude the county from making a determination otherwise. Okay? If they say it's fine, then we go on to what's called a military compatibility permit. The military compatibility permit is the entitlement stage. So that's like a rezone, but what it does is it specifically limits it to that particular use only. Whereas in a typical zone change, you get a whole bundle of rights that you would get. This is very specific about what you can and cannot do. Okay?
Matt, one
Yep.
more try.
Sure, no, that's fine.
The compatibility used in the military said, yeah, this is fine or not fine. As they progressed with new planes of F-35 and whatever they'll have after that, can they change the dynamics a little bit? So I say, hey, this is a little bit noisier than it used to be. We want to push something out a little bit further.
The answer is the military, no. Because it's state law, that would take a change in state statute in order to adjust where those high noise or accident potential zones are. Could they do it? Yes. Practically speaking, are they going to do it? Well, they pretty much said no, we're not going to, because it was a very big political fight to try and get those established anyway. And they've done some environmental tests in what is that, Air Force Base in Florida. I can't.
McGill?
The one in the.
McGill, isn't that McGill?
No, it's the one off the Panhandle in Pensacola, I think it was. Anyway, so what they've established is that the F-16 and the F-35 have very similar noise patterns. So if you're not concerned about one, you're not going to be concerned about the other. And since they've shifted most of the flight operations from the F-16s to the F-35s, and they're still ramping up those, they haven't seen a noticeable increase of noise complaints. So eventually they're going to ship all the F-16s over to Holloman Air Force Base. And it's not just the Air Force. Luke Air Force Base, just as a side note, trains anybody that purchases the F-35 from the U.S., they train their pilots there. So right now they've got pilots from Taiwan, Singapore, Norway, Italy, Turkey, all the friendly countries, basically. They'll train them there, and they have their own squadrons before they send them back to their countries to, work in the military. So, anyway.
Thank you.
Sure, no problem. So, just briefly, what was the outcome? We had to update the comprehensive plan and our area plan. With respect to the comprehensive plan, what we did is we designated the high noise reactive potential zones as something called military compatible. That basically says whatever's in the state law and what's allowed is what you get. It also explains some of the requirements that jurisdictions must follow and updates the land use map, that's it. Now, with respect to the zoning, it's a little more interesting. It establishes an overlay zone. It doesn't rezone the property, but it's an overlay on top of the existing zoning that is there. And it's called the Military Airport and Ancillary Military Facility Overlay Zoning District. That's a long title, but that's basically what it is. So what does that mean? Any use in the chart, the land use chart, and I'll show you that in the next slide here, that says yes, you can do it, that means you can do it. If it says no, you can't do it, it could still mean yes if both Luke Air Force Base and the local jurisdiction mutually agree that the use is compatible. That's why we have that compatibility determination. So if they say something that's no, they can still get it. We'll send it over, and if Luke says, yeah, it's fine, and comes back to us, then we also can say yes, and they can process that forward. Also, if uses are not listed on the chart, which in our instance, probably about 98% of them are not, because the land use chart was actually developed by some folks out at the Pentagon, and they don't really reflect actual land uses. We'll send it over to them for compatibility determination. So, what's the result of that? So this is the chart itself. Oops. I want to tear there. This is actually taken out of the state statute. It's in our zoning ordinance, and it's got just a couple differences that I'll go over. But you can see it's actually a land use chart. So up at the top, the location, the noise contour of the APZ, and the type of use. Now, here it's a little hard to see, but you can see it says single-family residential that is a subject of zoning approved on or before December 31st of 2000. Well, in Maricopa County, that's everything, because our zoning ordinance dates to 1969. So everything in the county was zoned. So one would think that it says yes, 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 like I mentioned. But because of the disagreement and the settlement agreement, that yes has added a little footnote, number 19. It's a little hard to see there, but I'll go over that. You'll also see that there's a lot of non-residential uses that are allowed. And most of them, as you go further out, are yeses. As you get a little bit closer to the base, some of those yeses turn into no. But commercial, industrial types of uses, typically those are a yes. And we're seeing quite a bit of that actually develop out there. So that's a good thing. Now, if you go to the back, where we have our footnotes. Footnote number 19. So what does that say? That's hard to read, so I'm going to read it off the paper. It basically says new residential permits and expansions of existing residential development are only allowed under 3 circumstances. One is that if they had a vested right prior to 2010. And it defines the vested right as A, you had a building permit, and you had already started construction. That's what a vested right would be. 2, and this is the important one, is that if both Maricopa County and Luke Air Force Base mutually agree that the use is compatible, like I had talked about. And then the third one was if there is a land use variance that was granted by the county. And I'll talk a little bit about that. In effect, none of these really apply anymore. And I'll talk about why that is. So, the results. We no longer have zone changes. We start with the compatibility determination right here. And then if you get that, the military compatibility permit is actually the entitlement for the process. We process them similar to a zone change. It still has to go through public hearings, things of that nature. Board of Supervisors, when they're making determinations, have to put it in record that the standards and whatever the land use is considered compatible and consistent. And then we also have an issue with a lot of these parcels are bisected by these noise contours. So part of it's in, part of it's out, and it acts as a zoning boundary. Well, that becomes kind of problematic on some of these substandard lots. So we process some variances on some of those as well. Especially when we have some where the home is outside, but the pool and the shed are actually inside. That's fine with us. And we actually see that quite often, more than I thought we would. So we started down this process, and almost immediately 2 problems popped up. The first one was that the statute says, and the settlement agreement says, expansions of existing residential provided both parties mutually agree. Well, we were starting to get a lot of applications, these compatibility applications, for people I want to put a patio cover on. I want to add a bedroom. I want to add a garage or a shop or something like that. And these things were piling up, and we would send those over to Luke, and Luke was always, yes, it's fine, fine, fine. So we finally said to him, well, look, you don't care about these types of things, okay? But this is creating an administrative nightmare for you and for us and for the people that have to apply and wait for the decision, and the building permits are waiting. So why don't we sign a memorandum of understanding that basically says expansions of existing residential uses are fine, provided you don't change the use of the property. In other words, I can't go from a single family and add on bedrooms and call it a duplex. Because now we're going from single family to multifamily, and that's a no-no under the state law. But if you're simply expanding an existing and lawfully permitted single family home that existed prior to the state law, it's not a problem. So that cut down on the workload quite a bit. The second problem was even bigger, and that's where we were getting a lot of applications for new single-family homes. Because it says, land use is compatible if both parties agree. Theoretically, that would mean residential. So we were getting a lot of these compatibility applications saying, new home, I want a new home. And we'd send them to Luke, and Luke would just summarily say no, 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 no. So we finally went back to them and said, look, you're not going to approve any of these. It's a waste of the applicant's time, it's a waste of our time, and a waste of your time. Let's enter into another agreement that basically says, blanket, new residential is a non-compatible use. Therefore, we will not even accept applications for building permits or compatibility determinations in those areas, period, end of story. So we entered into that agreement in March of 2014. And since then, we haven't even accepted applications for permits for new residences or these determinations.
Matt, would that include a demo and somebody had a piece of junk out there, they went to demo and put a 3,000 square foot bigger place? Would that prevent that?
It doesn't necessarily prevent it. There's some nuances that we're dealing with right now. If they had a lawfully permitted home, okay, and they wanted to simply replace it, it's not a change of the use, and it's not a new use you're establishing. You're simply replacing the existing use that's there that was lawfully permitted in the first place. Then that would be fine. Same with if there was a destruction of fire. Now there are some time limits on how long you can do this before you lose your legal non-conforming status, but for the most part, those replacements are fine. You can't add an accessory dwelling unit, and if you had a bare piece of dirt, you can't do a new one. Okay. So that's that. So the question is, and this often comes up, can I build a new home in this high noise or accident potential zone? Well, if you remember, I talked about the 3 criteria, the 3 tests. Must have a vested property right established before January 1 of 2010. Well, here we are almost 9 years out. That's no longer applicable because any permits that were started are either finished or expired. And if they're expired, they're not vested anyway. Maricopa County and Luke mutually agree that the use is compatible. Well, that's not applicable anymore due to the 2014 MOU. And then what if they receive a military land use variance? This was actually added to the settlement agreement, and it really makes absolutely no sense. Because what it says is the Attorney General can direct the County Board of Supervisors to consider a land use variance at their discretion only. And that the board, if they deny it, must deny it not because of anything other than military compatibility. Well, two problems with that. One, the county doesn't have land use variance authority in the first place. We can only vary development standards, height, size, lot coverage, things of that nature. And two, if the board turned it down in the first place, they probably turned it down because it was not compatible, or Luke said no. So why would we come back and say now it's yes when Luke said no? So it's a circular thing. So in other words, these three things are off the table. So the answer is no. You can't build it at home. So, in summary, this whole thing, again, it's a 15-year dispute, ended in a courtroom. They upheld the law. It's an interesting read. You can read about what the county's position was, what the state's position was in that summary judgment. The county was ordered to comply. Again, it doesn't just affect unincorporated county. So if you do any type of work in the cities or towns that are affected, I would definitely check with them to see what their rules and regulations are. Again, we don't allow residential uses. Non-residential uses are typically allowed. Very few, I think, have actually been turned down, but it's on a case-by-case basis. That's what we determine what's allowed. Again, I would recommend becoming familiar with Title 28 if you have any of that. And of course, our county zoning ordinance is available for you on our website, and that has the whole overlay zoning district and all the rules and requirements on that as well. So, with that, I'll be happy to answer any questions. I know that was a lot of information I threw at you, and a lot of confusing information. I understand because it's very confusing for us too. So it always seems to be a moving target. But at any rate, so I'll open it up to any questions you might have.
Just have one question.
Sure.
It has nothing to do with the military, just an unincorporated area, Maricopa County, R43.
Mm-hmm.
It says one residence. How do you get around the casita issue? Is the casita not considered a residence?
No, the casita within the high noise potential zone.
No, it's,
Oh.
it's another part of Maricopa County unincorporated.
Different rules. Different rules. In a rural 43, we would allow an accessory dwelling unit. One, provided it isn't a permanent. In other words, you can only have. It has to be accessory. You can't have more than one lot of record per parcel. So in other words, you can't have a separate home and then have it addressed off of that. So if it's an accessory dwelling unit, you can do that.
One mailing address?
One mailing address
And
with an accessory.
One electrical meter. If you're, let's say you're SRP, do you have to piggyback the electrical service off the main house, or can you have a separate meter? Because if you have a separate meter, you need a separate address.
One of our building officials says yes.
You have to piggyback it.
Right, so you have to take the electric from the house, from the primary
From the primary
house,
dwelling
SES,
to the,
and you have to go
sub it out to your.
underground, and you can have a sub-meter on the casita, but you just can't have a separate SES and separate service.
That is correct.
Because SRP would require a separate mailing address.
Correct.
Thank you.
Because if you have two separate addresses, it's basically two units on one lot of record, and that's not allowed in the zone.
And then it wouldn't be a casita, it would be a separate.
Exactly.
Right.
I had a question back here, and then one over here.
What was the, I have two, one was, what was the reference to that decision? It was CV 2008, 109301?
It was.
019?
2008-019301. And it's a Superior Court case. There you go.
The other question I had is, you mentioned all the restrictions and everything. That is only up to the 65 LDN and the APZs, right?
Yes, for land use restrictions. There's a larger area called the territory in the vicinity of the military airport, where the use isn't restricted, but if you build a home or any type of structure that's habitable or where the public is received, there are noise attenuation requirements that are in the building code.
I hear of these graduated density requirements. Is that something that the county doesn't deal with outside of the 65?
Well, the graduated density concept actually was developed by the county in its
Okay.
White Tank Grand Avenue plan, and then it was borrowed by Luke Air Force Base. And basically it says, even though you're outside the noise contours, it's not good to jam a bunch of homes up against it, okay?
Okay.
So basically outside of that, from a certain distance, it's compatible or generally compatible if you have this density. And then you go a little bit further and you can have a little bit more density. And then the further you go out, even more density. It's not a restriction, it's a guideline that the Luke Air Force Base issues.
So when we file for any of the, either comp plan amendment or rezoning or whatever in that area, outside of 65 LDN, but in this graduated sort of density
Yes,
area,
we
then-
would look at that, what is the graduated density? So in other words, I've got the 65 noise contour and I want to put a bunch of apartments up against it. Luke is going to say that's a pretty high density. They can't do anything to stop it because it's not restricted under state law, but practically speaking, we're going to look to them, and if they say, yeah, that's not safe and that's not appropriate, we're probably going to say the same thing.
And what, is there guidelines related to that density that are published? The density?
Yeah, it's not actually on their website. Their graduated density concept is on the Luke Air Force Base
Okay,
website.
okay, thanks.
I just don't remember I know it's like from 0 to half mile and half mile to 2 miles and then on, but I just don't remember what the actual density range is.
Thanks.
One final one, sorry.
Oh, you're fine.
If a city, Glendale or Surprise, for example, annexes into an area that you have control, or you have these MOUs with Luke, does the MOUs carry over to them, or they have to reinitiate their own?
No, they would have to reinitiate their own. These are just memorandums of understanding between the county and Luke Air Force Base as to how we're going to proceed with applications. The actual restrictions, they would fall under whatever guidelines or regulations, I should say, that they have enacted. Anybody have any other questions?
I just want to make a
Sure.
comment. I just want to say, not my area of expertise, but I really enjoyed your presentation, and gives me a better understanding when I'm driving out in that area and I see what is being developed. It's very enlightening.
Yes. Yes. The cities, since the law, the cities and the county have really held the ground in terms of preventing residential development of those areas. We have a pretty good quality control system at our office to make sure permits don't get through that shouldn't be permitted, because we deal with high volume number of permits, and we're afraid that something might slip through, because then we, obviously have to take that up with the Attorney General's office. So we've been pretty good in terms of making sure that we meet the law, and then, trying to be as accommodative as we can with respect to non-residential type of development. So.
It's not only noise, it's vibration also.
Yeah,
Yeah.
and the accident potentials.
The other day I was driving, I was northbound on Litchfield Road between Glendale and Northern, I thought I had a car accident.
Yeah.
But I didn't have a car accident,
Mhm.
I had 35 above me,
Yeah,
and the car started to shake.
yeah.
And I
Yeah,
thought something
when
hit me, but I looked up, and I said, oh, that's what it is.
Yeah, when they take off with their afterburners, it's pretty amazing. I actually was very fortunate to get a tour of the Goldwater Range when they were doing live fire exercises, and that is amazing. It's funny because as big as that is, they only use a very, very small footprint of that. They are very conscious of protecting the natural integrity of that. As a matter of fact, before they do live fire exercises, they announce it, and they have biologists that go out there and make sure that there are no bighorn sheep or any type of animals that might be affected. And if there are, they call it off. So they're very protective of that. But it's very interesting to see these live fire exercises. You've got these huge, it looks like a dartboard, these huge targets in the middle of the desert. And these jets come in, and before you even hear the jet, those things are exploding, because their ammunition is going faster than the speed of sound. So it's fascinating. And they got a tower that you can watch and observe this stuff. It's pretty cool. So. Any other questions before we break up? Well, again, thank you for coming. I hope you found it interesting at least, if not useful. And you know, if you have any questions, you know, feel free to ask or give me a call at the office, and I'm happy to work with you on this. We've been working on it for a long time, so. So, that's it. Enjoy the rest of your conference and enjoy the rest of your day.